Welcome back to r/LegalAdvice, where people ask questions, get advice, and we get satisfaction. If you are new around here, please don't forget to subscribe to the channel to join our awesome community, and without any further ado, let's dive right into the stories. And the first one is titled, ID, Landlord is charging us $50 per hole they find in the walls. They found 40 of them after we moved out and demand $2,000 to repair them. And I suppose ID means Idaho. In our lease, the landlord forbids that tenants put holes in the walls, so no nails for hanging pictures, decorations, etc. They reserve the right to charge for these repairs if they find any after we move out, and they will charge us more if we attempted to repair them ourselves. My wife is big on decorating, so of course we figured we could try to cover these holes up upon leaving, and if they find them, they probably won't charge much to patch the holes. In hindsight, this was very stupid and careless on our part, and it will definitely be a learning experience for us. We did our best to cover the holes and moved out. They just sent an email stating that they found 40 holes in the walls and noticed that we tried to fix them ourselves. Their rate for repairs is $50 a hole, which brings the total to $2,000. This rate seems extremely high. While I am not too familiar with what it takes to patch a hole, I am pretty confident that $50 per hole is not a reasonable cost of labor and supplies. Do we have any recourse to lower this amount? Yeah guys, $50 per hole, that indeed seems unreasonably expensive if you catch my drift. Anyway, a person in the comments said, a judge may only accept actual cost, not the unreasonable stated cost. That is your only hope if the landlord won't come down. I am not a lawyer. And another person said, the cost will depend on whether they are patching a hole versus replacing drywall. You may be able to fight the amount, but if the lease expressly forbid holes, you are likely over a barrel for a lot of it. In the future, do not take actions that directly contravene the contract you have signed. If they are withholding this amount from the security deposit, your recourse would be to sue in small claims for its return on the basis that the charges are unreasonable. They have 21 days after move out to return your deposit or send you an itemized list of deductions. This will list the costs for repairing your damage. If there's not a security deposit, they will need to sue you for payment. Do not ignore the suit, show up and attempt to show that you are being charged too much. No, but honestly guys, puns aside, obviously the OP did something very wrong, because you shouldn't do something like this if you have signed a contract before. However, $50 each does sound really expensive. Please let us know what you think about this legal advice story in the comments. And the next one is an update to the landlord charging $50 per hole story. So here is a final update, probably not as exciting as you would hope, but I am just glad it is over with. To clarify from the previous thread, the holes were made by thumbtacks. They are super tiny, we probably only made 15 in our time living there, but I guess they found more. We probably fixed these holes in our hustle and bustle of cleaning and moved out. I got mixed advice in the thread and decided to talk to an attorney that specializes in landlord-tenant law. He looked over our lease and said it was one of the most tenant-unfriendly leases he has ever seen. Because we attempted to repair the holes ourselves, we were out of luck as far as the actual repair costs were concerned. The $2,000 bill was obviously way too much and was just a scare tactic in an attempt to keep the deposit. He suggested that we offer them to keep the rest of our deposit, $200, if they let this go away. In the conversation with the landlord, which I recorded after he was insistent on talking over the phone, not over text, he claimed it cost their maintenance person $300 to patch the holes. Something about having to let the patches dry and come back the next day. They expected no less from us to cover their costs. That amount still seemed absurd, and a handyman I talked to agreed unless they had to repaint the whole apartment. We countered with our lawyer's advice, let them keep the remaining $200 from the deposit, and the landlord said that if we didn't hear back by Friday morning, then they have accepted our offer. We haven't heard anything, so I am hoping that is a good sign that this ordeal is done. This was a learning experience for us. First, we are going to thoroughly read our future leases. If we find anything questionable, we will ask for clarification and possibly as an attorney. Secondly, we are going to video document the state of our apartment when we first move in to show any pre-existing damage. Third, we are going to ask for a move-out walkthrough or else do a video walkthrough on our own. Section 15 contains the info on whole repair fees. TLDR, $2,000 repair bill was a scare tactic. Didn't have to give up more than our deposit. Be smart about who you rent from and protect yourself when you move out. And guys, I'm curious, has your landlord ever tried to scam you when you moved out of your apartment? Did you ever have any similar experiences as the OP in this story? Let us know in the comments, and please, if you enjoy my content, I would very much appreciate it if you could like the video, because that helps my channel tremendously. Thank you so much in advance, and now let's continue with the stories. And the next one is titled New York City, frozen pipes in bathroom 3 days in a week, no toilet, sink, bathroom only, or shower water. Can I ask for a reduce in rent? How do I go about this? The plumber has been called in once and will most likely be called in today again. Management has received notices, everything is done online, so there is documentation. We pay about $2,400 in rent. What is a fair break to ask for, if any? Plumber thinks that it is poorly insulated pipes, but I cannot imagine my management company is going to break into the bathroom walls to fix it. We are scheduled to have 3 sub 10-degree days in the following week. What is my best course of action going forward? Am I due for any break in rent? I rent from a large management company, if that matters at all. And a user in the comments said, even insulated pipes can freeze when the temperatures get cold enough. Did the plumber who diagnosed the condition of pipes he couldn't see also bother to tell you to leave the under-sink cabinets open and to run a thin pencil-width stream of water until the temps rise, or at least while you're not using them, like if you are at work or sleeping? And another person said, practical advice, not legal. Once you get the water running, when it is really cold, leave it on a slow drip. That's enough to keep it from freezing. Usually the water freezes at a specific point, such as an isolated joint, and that drip is all that is required to make sure it doesn't freeze there. I had a lot of problems, live in Sweden, and we had a few really cold winters before I figured that out. Now I have solved the problem with pipe insulation. They had a brass joint in the incoming water in the foundation under the house, and that was the point where it froze. 2 layers of insulation fixed it, but as a temporal fix, the drip is great. The next one is an update to the frozen pipes story. Hello everyone, I got lots of feedback, so I just wanted to share the result. I emailed the management company the following. For the last 3 days, our water pipes have frozen, leaving us with no water for most part of the days. When the plumber came in, he noted that the bathroom is very cold, it has no heat, which is causing the pipes to freeze. He advised us to leave the water dripping to avoid overnight freezing, which we followed. As a result, we now only have hot water on tap and in the shower, with no cold water and no water in the toilet. While leaving the tap dripping is a stopgap solution, I am very worried about the water situation in the future when the cold will get worse. It is obviously irrational to assume that the plumber will be available every time the water stops pouring at midnight. On top of that, of course, is the inconvenience and distress of having to live in a house with a bathroom with no or at best scanty water. I request you to look into this recurring problem and perhaps suggest a way to compensate for the distress my partner and I have been undergoing through the last few days. Our monthly rent is $2,623, which brings our daily rent to $84. We would like to be compensated for the 3 days we haven't had water, $253, and for the consequent days the problem persists. We plan on paying rent today and look forward to hearing of a solution from you soon. They got back to us today and credited $350 to our account. After the above email, we were out of water the following day as well. The plumbers pretty much spent 8 hours in our building making fixes. Shortly after this, they shut off the water/heat for the entire building and made additional fixes to the boiler. Whatever they did has helped a lot, as our apartment has been toasty ever since with no water problems. A lot of Redditors gave the helpful suggestion of running a drip to prevent pipes from freezing a plus advice. And guys, I'm curious, I know that some of you live in New York City, and I would like to know, did you ever have similar issues, whether it was in New York City or anywhere else in the US? Let us know in the comments. And the next one is titled, "Purchased a home where my garage is attached to the neighbor's house. Neighbor is claiming it is theirs." This is Wichita, Kansas, or whatever you pronounce that, I'm sorry. The story is this: I purchased a rundown property. When I looked at it, I assumed the fence lines were the property lines, and I was relatively correct. However, the garage that is on this property is actually attached to the neighbor's garage. It is not uncommon in our area for there to be shared garages, so I didn't think much of it and didn't ask about it. After the property is sold to me, I talk to the neighbor and it turns out to be the seller's daughter. She informs me that the garage is not mine, as it is clearly a part of their home and it wasn't intended to be sold to me. I immediately order a survey, and 11 feet of the garage, basically the one car part, is part of my property. I inform the daughter and ask that her parents contact me. They do, and I offer to sell them the garage and legally change the property line so this will never happen again, even though I assumed the garage was mine. They offer me $500 and I have declined that. They are insulted at my $5,000 asking price, so I've decided to just keep the garage, build an interior wall, and continue with my plans of using it for this property. My questions are, they say they didn't advertise the garage for sale, so therefore it hasn't been sold. Is this correct? They never changed the property line, and I have emails where they acknowledge that the one-car garage is on my property. What is the precedent here? And a user in the comments said, "Get a real estate attorney to review the situation. This is no longer a do-it-yourself project. Do not start building partition walls or taking down the garage without getting professional input. The last thing you need is for your neighbors to sue you over the cost of tearing down your boundary wall. Your attorney can look over any relevant permits and other documents to figure out who owns what part of the garage and advise you on how best to end this dispute." And another person said, "You've been given good advice, contact your realtor and real estate attorney, but one thing that jumps out to me is if half the garage is worth $500 to them, then offer them $500 for their half, so there's no fight. Hell, offer them double what they offered you for their half. See if they think $500 to $1,000 is fair for the garage and land it sits on." Update: garage attached to neighbor's home. After a few emails that remain very professional and respectful, the owner told me she had consulted legal counsel and was directed to settle with me. We could not reach a settlement, so she acquiesced and told me I could take possession of the garage. Her daughter, who lives in the property, was to provide me the keys and accompany me. When the time came to meet with the daughter, that is where things went sour. Daughter and her boyfriend were very hostile, violence was threatened but avoided, and I ended up letting myself into the garage. I told the previous owner that I wouldn't touch any of their belongings and would give them plenty of time to move things, as they did have possessions in it. So far, things are calm and the garage is mine. Thank you everyone. Charged with fake ID in Washington was not fake. Hey guys, although I'm really upset about this, I will try to save you the diatribe. I am a first-year student at a university in Washington State. Because I am not a traditional student, I am currently 24 years old but admittedly look young. I went to a liquor store 3 days ago to buy some booze for the weekend. I live off campus and not in dorms, and so there is no issue there. When I went to buy booze, I was stopped by an undercover police officer that was just hanging outside the store. He asked for my ID and obviously I gave it to him because I am legal. He then claimed my ID was fake and said he would run it. It is a New Jersey ID, so I guess he thought out of state means fake. Anyway, he then said that my idea was not confirmed as real and that he was charging me with possession of a fake ID. So not only did he give me a ticket, but he took my real ID that I need to drive. I was not charged with any MIP or anything like that, so it makes no sense. If he thought I was underage, would he do that too? So I had a friend come pick me up and we drove to the police station to complain. The supervisor said it was out of his hands, but they knew it was fake and would be handled as such. I have no effing idea what to do now. I cannot drive without my license and I don't want to go to the DMV to get a new one if it could cause issues. With that said, I don't want to wait until my court date in June to sort this out. If the police refuse to give me my ID that was seized as evidence, can I just go to the DMV to get a new one? I have a summer job and cannot have a charge on my record, so what in the hell do I do? Between college and living, I don't make enough for an attorney as my job money goes toward tuition. Student legal services also said they could not help with a criminal matter like this. Where do I go from here? Is there an avenue to end this that I'm missing? TIA. Guys, I'm curious, did something similar ever happen to you? Personally, I never had a fake ID, but actually my girlfriend had one in Thailand because you are allowed to drink there at age 21 and back then she was 20 years old as far as I can remember. Obviously over there you don't get charged for having a fake ID. If you have any idea what OP could do, let us know in the comments. And by the way, a user in the comments mentioned, keep complaining up the chain of command. Bring whatever ID you have that can verify. But I gotta say, other than that comment, there have not been many insightful comments in this regard. And now we will read the update to the ID story. Primarily, I want to thank you all for the help and providing clarity. I was clearly getting some tunnel vision and not thinking through the possible routes to handle this all, so all of you here really made my life easier. I ended up calling the court who transferred me to the prosecuting attorney's office. The woman I spoke with was incredibly helpful and told me they obviously are not charging me with anything and that the idea to take the passport in was good. She actually called the police department for me and told them to give my ID back if I brought in a passport as you all suggested. She also stated that the only record of the incident would be internal. Yesterday, I went to the police station with a passport and got my ID back within about 5 minutes. The police chief talked to me and told me how sorry he was and said that the officers that made my life harder would be disciplined. While that may or may not be the case, I really appreciated the apology and it seemed like it came from the heart. Although I was initially scared about talking to the prosecutor, especially with the whole don't talk to the police thing, she was more helpful than I could have ever imagined. Even though the police caused a minor annoyance, the resolution of the situation was overwhelmingly positive and the people I met with there this time around seemed really genuine. Thanks again for all of your help and I'm happy to say that it came to a positive end. And the next one is titled, texted a girl sexually on an 18+ only app called Scout. Next day her father calls and says she is a minor and wants $4,700 tonight for counseling and compensation or he's going to file charges. Help. I messaged this girl on the app a couple days ago saying hey. She replied and said, message me your number and I will text you. Keep in mind, to use the Scout adult app, you need to sign an agreement that you are at least 18. I was an idiot and gave out my number. She texted me the next day and we sexted about 10 minutes. I received only one nude pic and it looked like just some random picture. I sent a few things and she stopped texting. Today her dad calls me and says she is actually a minor and he's willing to not press charges if I am willing to help him out by Western Unioning him almost $5,000. I am really scared. I am 25, live in DFW, which I suppose is Dallas or Fort Worth, but please correct me if I'm wrong, and never been in any trouble my whole life. I also have a great career. She supposedly lives in SC somewhere. Is he bluffing or not? That is what I'm faced with. If he is not and he does press charges, will I be okay since she lied when signing up for the site? The last thing I want to do is go to court. Update to the dating app story from before. I did as you guys have informed me, I blocked his number and did not hear anything back until the next day. When I woke up, I had another text from him. I could tell because it was the same area code on a different phone. It said, my name.
Why did you block me? I was starting to think you're a nice guy, but I guess you want to get the police involved. It would be a shame to expose you at work like this as well.
Also, I received a call that had my area code in it that left me a voice message. I listened to the voice message and basically just said,
hey OP, I'm a sheriff with
my local police department
and I have a complaint about you with so-and-so's daughter and her father. Please call me back as soon as possible.
I have a friend who knows an undercover cop. He traced back the original numbers the guy was calling me from, which was both disposables. He checked the number from the supposed police officer, disposable as well. He called it and went straight to a voicemail. I then called my city police department to see if there were any records or complaints filed against me about anything not in the database at all. Then I called the police department for another town over. I was told it was where the number was from or something like that. I don't know how numbers work like that. And I talked to a sergeant for criminal investigations. I told him everything that was going on. He said,
"Yeah, it's a scam, don't do anything."
He kind of had a laugh about it. So that is where I am at with this right now. I also changed my phone number just to stop this crap for good. I did not get much sleep last night. I've never been involved with something like this before. Thank you guys for helping me out. I think I would have seriously sent money to the guy if it wasn't for you all telling me it is a known scam. Edit, thank you all for the positivity in here. This is actually my first time posting on Reddit and has been quite the experience. I have my main account but just been lurking with that for about 2 years now. If there is anything I can do for you guys, I would do it. By the way guys, I'm curious, have you ever gotten together with a girl or a boy over a dating app or the internet in general? You know, in my opinion nowadays, that is definitely a viable way to meet someone. But I'm also aware that in some societies there is definitely a social stigma around that. Let me know how you feel about this. How can a judge order my cousin to pay child support even though the baby was never even born? And guys, I gotta warn you, this story is kind of weird and it seems like the OP, or rather his cousin, is the bad person in this story. But let's see what you think about it. Hey r/LegalAdvice, so I'm not saying my cousin is not a jerk, because when I tell the story about what happened, I'm sure everyone will think that he was. I just have a question about the whole thing. So, my cousin got some girl pregnant and he did not want to be a dad, but she wanted to keep it. Now, he is a jerk for doing this, but he got that abortion drug and gave it to her in a drink a couple of times. She has heart problems or something and she ended up in the hospital and she lost the baby. The cops figured out what he did and he got charged for trying to kill her and her losing the baby. So he has to be in jail at least 18 years before he can get parole or get out. But the judge also figured out how much he would have had to pay her child support under the Florida law for 18 years if she has not lost the baby, and the judge made an order that my cousin has to pay her all that money too. Now, as I said, he's a jerk and I don't think he did a good thing. But I just want to know, how could they make him pay child support for 18 years if the baby was not born? He tried to appeal and lost. My aunt and uncle are really upset about what he did and it is a sore spot, so I cannot ask them, and my parents won't talk about it neither. And a person in the comments mentioned punitive damages are awarded by a jury in a civil case. If a judge awarded this as part of a criminal case, it is some sort of restitution, not punitive damages. And now onto the update to the baby story from before. My other post was here, so I want to say thanks to everyone who tried to help and answer my question. I did learn a lot, but I still was not sure all about things like punitive damages or restitutions. So I asked one of my teachers and I told her all about my cousin, and she listened to me and explained it. She said that my cousin had to pay because he got sued by the girl he gave the drugs to. That is why he had to go to court 2 times and have 2 different lawyers, because it was 2 different things. She said the money my cousin has to pay for 18 years of child support was what she won from suing him. So now I understand and I learned some stuff about the law in Florida and everywhere else too. My teacher is gonna talk to my parents for me too, so they can know I don't like having to talk to my cousin and to visit him. I know and think what he did was bad, and I'm sorry if my words were not telling that like some people said. I'm going to high school next year and my teacher said I can take classes about law there. Thanks for helping a guy out and getting me to learn some stuff. And the next one is titled, Toronto, landlord let cleaners into my condo without consent. $1,700 worth of property stolen. So I just moved from one rental condo to another here in Toronto. I have the original condo until March 31st. Since I had both units for a whole month, I had left some things behind to move over at my leisure. Earlier this week, my property manager confirmed with me he would be doing his inspection on March 31st, which is tomorrow. I agreed and told him I would go leave the keys at the concierge, and by the way, I think that is the French pronunciation, I have no idea how to say that in American English, for him to pick up on the 30th, and that I had a few items there I was still dealing with. Today is the 30th and I went to collect the last of my belongings and drop off the keys. They are gone and there are a bunch of cleaning supplies there. No cleaning has been done. I call the property manager and ask where my stuff is and why is there cleaning stuff in the condo. I did not give consent for anybody to enter prior to the 31st. He says he will call the cleaners and call back. He calls back 15 minutes later and says,
"There was a scheduling error on the cleaner's part. They accidentally thought your items were garbage and threw them away."
Naturally, I lost my shit. He kept putting it on the cleaners and I insisted he was at fault for providing access to my condo without consent to a person who stole from me. He facilitated theft in my opinion. Anyway, it is an actual property management company and not just one person. I don't at all trust them to repay me the $1,700 for my stolen items. I sent them a list and he said he would review it with their team tomorrow morning and respond immediately. I'm going to call the tenant board in the morning and I'm not sure if I should file a police report tonight or wait and see what happens tomorrow. Advice on that would be good. But I am mostly looking for someone to tell me what I can expect if they don't reimburse me. Do I take them to small claims? Take the cleaners to small claims? Or maybe even both? Do I stand any chance of getting the full amount through this process? Thanks for any help. Update: police report has been filed. They have to assign a detective to it before anything happens on their end. They told me to follow up tomorrow and indicated they may assist in attaining security footage if necessary. I am not expecting much out of the police as it has been indicated by posters here that this is a civil dispute. I also contacted the cleaning company to find out what time they were there and get his version of events. He apologized, admitted fault in misunderstanding the schedule and confirmed that he threw every item down the garbage chute. Now I am definitely going to try to obtain the elevator security camera footage to see if that is true or not. I filed a T2 form this morning, 31st, with the tenant board indicating an unlawful entry, explained everything with dates and times, and there is a section where you propose recourse, one of which is reimbursement for lost or damaged property. I listed each item as detailed as possible with values. They will schedule a hearing in 3 to 6 weeks. I can cancel this if the property manager settles with me before then. The property manager is having a meeting with their team this morning to discuss my list of stolen property. They are to respond by 12 PM today, 31st. I told him if I don't hear from him, I'm calling him at 12 o'clock. And now, update number 2, I got a call back from the PM after their meeting. They discussed with the cleaner and the cleaner concedes it was his fault and is willing to pay. They said he does not make a lot of money and asked if I would accept a reduced amount. I told them the number I gave is what it will cost me to replace those items and I expect the full amount. The cleaning company should have insurance and I'm not made of money either. The property manager, I assume, discussed with their legal counsel during the meeting. They are insistent they have zero fault in this situation as they have a work order with the cleaner for March 31st. I argued that I never agreed for anybody to enter on the 30th and they facilitated the unlawful entry by handing over the keys. They want to work with me as a middleman to settle with the cleaner. I told them if he agrees to pay in full, that is fine. If not, I am proceeding with my T2 claim against them with the tenant board and we will have the hearing. They will discuss with the cleaner again and let me know today. Guys, I'm curious, how would you handle this situation? It seems like the cleaners, aka the company behind them, does not really want to take any responsibility, so I think the OP is handling it quite well. Either way, let us know what you think in the comments. Update to the Toronto landlord story from before. This morning the police called me back to file the police report. The case was sent to 14th Division and has to have a detective assigned to it before they proceed with anything. I am supposed to call back tomorrow. They indicated they could help attain security camera footage from the building if needed. Other than that, I don't expect much, as posters here have indicated this is a civil matter. I then called the property manager around 9 AM to get the name of the cleaning company and time of entry. He did not know the time, so I called the cleaner myself. He apologized for the confusion, said it was a scheduling mistake, and explained how tenants often leave stuff behind that he has to throw out. I told him the value of my belongings and ran him through the list when he questioned me. I told him to contact the property managers as they were meeting this morning, and I expect between the two of them that I will be reimbursed in full. Then I filled out a T2 form and submitted it to the tenant board. It says the reason for the complaint is unlawful entry by the landlord, and proposed remediation is reimbursement for lost or damaged property. I listed everything in detail and wrote out the whole story. The property manager's team had their meeting with legal counsel this morning. During this time, they contacted the cleaner admitted fault to them and offered to settle. The PM called me around noon to tell me this. The position of the property management company at this point is that they have a work order with the cleaner for March 31st, so they have no fault for their entry on the 30th and are not responsible for my lost items. They said the cleaner does not make much money and can only afford to pay a reduced amount. I told them that first, I expect to be paid back for the full replacement cost of my belongings. Second, as far as I am concerned, the property manager allowed access without permission to a third party without discussing it with me. They are responsible for the unlawful entry and ensuing theft of property. My issue is not just with the cleaner. He said he would call the cleaner again to see if he would pay the full amount. From what I can see in the Ontario Landlord and Tenant Act, there is no provision for a landlord to hand the keys over to a third party without discussing it with me first. A question I will be asking a lawyer is if the landlord is supposed to be present to physically unlock the condo. As a tenant, it feels like a violation of my privacy and rights to have an unknown person handed the keys to my home without me even knowing about it. I just got a call back from the property manager at about 6 PM. He says the cleaner is offering $600. I tell him there is no chance I am accepting anything but the full amount. Again, I reiterate that my issue is more with the management company than it is with the cleaner. He tells me that the cleaner will go through insurance and their attorneys will be real tough with me and expect receipts, etc. He says he was trying to do me a favor negotiating with the cleaner as a middleman. I told him he's not the middleman, his company is at fault, and I won't be individually battling the cleaner in small claims. I have already filed the T2 with the tenancy board against the property manager, and we will see what they award for damages from that hearing before any other avenues are pursued. Needless to say, this is now out of my wheelhouse as far as who I should go after for what. I think I am on the right track, going to the tenant board with the property manager and not chasing the third party contractor I personally had no arrangements with. I will be contacting a lawyer tomorrow to make sure I get this moving in the right direction. Any thoughts or comments on whether I am doing this right or not is appreciated. And now on to the last update to the cleaner's story. This is going to be long, there's a too long didn't read at the end. After those threats, I felt like I was probably correct in pursuing the landlord, but the comments were a bit of a mixed bag of advice. As I said I would, I sought counsel here in town. I saw a paralegal that was supposedly in this area of law referred through the Law Society. What an enormous waste of time. After I explained the entire situation to the paralegal and how I didn't know if I should go after the property manager at the tenant board or the cleaner in small claims or both in small claims, the guy basically despondently nodded and said,
"Yeah, that's a real tough one. What do you want to do?"
It was frustrating that a legal professional in Toronto could not give me any better direction than Reddit. I left no wiser than I arrived and decided to just go through the process with the LTB and feel it out. It did not feel worth my time or money to seek additional counsel. There was a preliminary hearing at the LTB in April where the property manager and I were each allowed to give our version of events, attempt mediation, and then the board member would determine if the case would go to a formal hearing. After telling my side of things, the property manager did not dispute any of the events. The board member said that the cleaner was an agent of the landlord and advised the property manager they would be required to pay any damages to me that may be awarded. This was very good to hear, as it finally confirmed I was correct to go after the property manager and not the cleaner. The property manager was cooperative and was pleasant enough to deal with. The board member asked us if we would attempt a settlement. So far, the cleaner had offered $600, the PM said they would add $400 to that for a total of $1,000. I said I would not take less than the full value of my items listed because I was confident I could prove their value beyond what they offered at a hearing. No settlement was agreed on. That was unsurprising and made sense to me. Even though the PM was not contesting the events and was likely going to be ruled against in a formal hearing, it was in their interest to make me prove the value of my stuff and get an order from the board for that amount. Then they could use the order to sue the cleaner later. If they settled it, it could be difficult to get the money from the cleaner. At the end of the preliminary hearing, the board member took down a statement of agreed facts to expedite our next hearing. Since we did not disagree on any of it, I'm not going to list them, but the gist of it is that they gave their copy of the key to my apartment to a third party without my consent, and they removed my belongings from my apartment. It was very clear they were not fighting me on that. The formal public hearing where the board would determine damages was a couple months later. I had receipts, mostly PayPal confirmation mails, for about $1,000 worth of my things that were taken. Then I had $400 worth of stuff where I had pictures of me wearing it with identifying brand markings and stuff showing. Also with printouts from websites where it could be purchased to show the monetary value. Then about $200 worth of stuff where all I had was pictures because they were irreplaceable items that I paid cash for. I had my girlfriend as a witness to what was taken and to confirm brands of clothing items. The full value of the items was over $1,800. I was expecting to be awarded $1,200 at least for the items. I could prove exactly how much I paid for, which is why I did not settle for $1,000, but was not confident about the rest of it. Before the hearings for the day started, the board member called out our names and said,
"Are you sure you cannot settle this one with the mediator this morning? I'm looking at the agreed facts here and..."
He looked over at the landlord and kind of shrugged as if to say the hearing is a formality at this point. Nonetheless, the landlord would not budge on it, so we waited 4 hours until we were called up for our hearing. After we went through all of the documents item by item, the property manager was given the floor. He tried to dispute the items that did not have receipts, specifically a pair of jeans worth over $300. Yes, seriously. The board member said that it is not a criminal case and it is not up to me to prove beyond a reasonable doubt every single item I listed. The burden of proof I had to meet for a civil matter like this was met through what I had provided. As the PM elected not to bring any experts, witnesses, etc. that could argue against the values I had stated or to say the items I was wearing in the pictures did not match the products in the evidence I produced, he had no reason not to believe me. The board member said he did not even want to hear from my witness because the evidence I produced was substantial and there was no contest from the property manager beyond,
"It is not a receipt."
The board member ruled in my favor for the full amount that we discussed for each item at the hearing, and I received the order stating such a week or so later in the mail. On my way out of the hearing, I asked the landlord what they were going to do. He said they had no interest in fighting it and would be getting the cleaner to pay for it. A week or two later, I received the check in the mail from the cleaner. This was a few months ago now. The check cleared and the matter is resolved. Thanks to everyone that offered their advice and comments in the other threads. And guys, unfortunately, we have already reached the end of the video. I hope you enjoyed today's stories, and if you haven't already, please also go to patreon.com/ripeyoutube, where I upload exclusive Reddit videos starting at just $3 a month. This is a great way to support me in case you are interested, and the chance for me to become independent from YouTube revenue. Thank you so much for watching. Please don't forget to subscribe and like the video, and I hope to see you again tomorrow.